And thank you for staying with us. It's time for Opinion Court. Please do get in touch with us. 22422 is our SMS line. And if you're online, please use the hashtag Opinion Court. Let me introduce my guest to you. To my immediate right is Sandra Ochola. She is a governance analyst. And next to her is Edward Kisiangani, our resident political analyst. Right across from him is Mark Bichachi, a communication strategist. And next to me is city lawyer Kamodo Waiganjo. And you're all welcome to the program. We are discussing various issues, beginning first with the fact that Al Ghurair this evening began printing presidential ballot papers after the Court of Appeal gave them the go-ahead. A 5-judge bench reversed the decision that terminated the awarding of the contract to the Dubai-based firm. And I'd like to get quick comment from you all on what you think about it. Sandra?
I think it's a good step towards the right direction, and one thing I'm happy about is that as a country, as voters, as citizens, there's a lot of uncertainty has been cleared moving forward, because you realize over the past week and a half, everyone was in a limbo, so to speak. We don't know whether we are going to have the elections or not. We don't know whether we're going to participate. Should we prepare? And then, of course, all these other incidences, what I've called before psychological warfare, so to speak, where we are being threatened with possibility of violence, you know. So it's been a very uncertain period for Kenyans, and I think the court pronouncing itself on the printing of ballot papers, it gives us a green light, so to speak, to move on with the process.
All right, Kamada.
Two things, and I think one of the things we need to affirm is the right of parties to go to court. I think one of the sad narratives that's appearing is where we almost act like it's wrong and erroneous for people to take matters to court, and they're doing this so as to challenge elections and postpone them. I think people must be allowed the opportunity to challenge processes if there's a breach of the law. However, when they do, that challenge must be based, especially on delicate issues like this one, it must be based on evidence. I think the unfortunate thing about this case is that while it was produced with a lot of fanfare, when it was eventually presented to the High Court, there was absolutely no evidence on the most critical issue about whether Al Ghurair was compromised because of its relations with the First Family, or whether it had been given undue preference by the IBC. Once the High Court found, as a matter of fact, that Al Ghurair had not been compromised and that it had not been given preference, the High Court was reckless in then going on to say that on an issue like public participation, that issue trumped the public interest in ensuring that you have a certainty in the date of the election. I think it was irresponsible of the court, and it was good for the Court of Appeal to say that once you have found that the IBC was allowed by law to procure directly, and once you found that this company was not compromised, then you needed to consider the only other important issue was to ensure that we have an election. So it's a step in the right direction.
Mark?
You know, the reality of this particular election is that, number one, in the interest of the public, we are honestly tired of this campaign mode. It feels like we've been campaigning since 2013, and what we want is this election to come and pass. I think the court's ruling today is in the interest of the public, and I think the politicians should really tone down the push towards making this an issue about proving conspiracy and theories that are unfounded. As the good lawyer said, the reality of the matter is the court case from NASA did not have substance before a court of law. And what I found strange, and I'm not a lawyer myself, is that they okayed 90% of a contract and said that 10% of it is wrong. Now, if correct me if I'm wrong, but a contract is wrong either in full or it can't be wrong in part. You cannot say that this is okay for senators and it's not okay for the presidential ballot. That's one. The second thing, I think it's critical that as a country we get to grow up to the point where we realize that when something is in the Constitution and it's a fixed date, it's not going to change. You know, it's like saying Christmas has surprised me and I have no gifts for my children. It's nonsense. We need to come to the point where, as a nation, we are not surprised by the deadlines we set for ourselves. No one put a gun to Kenyans and says, let's have elections on August 8th. We need to be prepared. And even the single sourcing from IEBC is also kind of at fault. They had 4 years. they had a long time to prepare for this election. As IEBC, immediately an election is over, it is your job and duty to prepare for the next one. So what really was the emergency? So the reality of the matter is, it's a good thing the politics is out of the window. We are sure we are voting on August 8th. Now the onus is on IEBC to meet one critical deadline. Do you remember that they said that Al Ghurair had a deadline of the 17th? So in as much as they have cleared, has the IEBC come out to say that now we'll have ballot papers on time? Because that's the next level that they need to clear up for the public.
Yeah, and I think they've said this will take about 10 to 12 days of printing, round-the-clock printing, and probably get it in on August 3rd. Prof, Mark has said that, has intimated that now the the political circus around this issue is over. Is it in fact because I suppose the bottom line for those who are against Al Ghurair was the fact that extra ballot papers were going to be printed by these by this firm for the presidential ballot, and there will be ballot stuffing, etc. Does this decision now put all those issues to rest?
On the contrary, and the politics surrounding this balloting will go beyond the election. And I won't be surprised if we even have a series of petitions, and they will quote this current situation as the basis for the petitions. It is not going to die out as long as political competition continues at the rate at which it is. But for me, I think for my brother Wakamoto Waiganja and Sandra, and partly Bichachi, you are out of order, because the way you have looked at the issue is really, in my opinion, for lack of a better word, a little naive. Because the situation is, for me, I really don't care whether people go to court or not. They have their choice. They can make that choice. The problem is that today, the Court of Appeal has invited us, invited the whole nation to embrace the idea that legislative law is superior to the Constitution. This is what the judges said, that you can pass a law on procurement and violate the Constitution. Look at Article 10 of the Constitution, upon which the High Court made a ruling. The national values, in fact, the starting of Article 10, our city lawyer can testify, is that all state officers are bound by these national values and the principles of governance. There is no option. If you make a law on procurement, and then you say if it is direct procurement, that becomes an option with regard to Article 10 on public participation. These judges have made a ruling which is populist, but it actually goes against the spirit of the Constitution. So that is my worry. It's not about the fact that elections will come. The second thing that they made a ruling about, which also shocked me, they alleged that, look, this ruling is about the question that the first family was probably had some unfair connection or discussion conduct with Al Ghurair. And they said they are backing the ruling by the High Court that in fact there was no evidence. But when they made their statements, you realize they were not backing. The High Court said that there was no sufficient evidence after in fact the newspaper cuttings. When you use sufficient, it is different from saying what the Court of Appeal said today. It is hearsay. Hearsay does not mean the same as not sufficient. Not sufficient means that you have some evidence which makes sense. They are pointed to some sinister motive, but when you call it hearsay, you dismiss it. So in terms of ruling, they did not even support the High Court position. They actually dismissed everything. So they cannot say the High Court the position is the same as what they ruled today, because them they called it hearsay, the High Court calls it sufficient. So in my opinion, therefore, I'm happy that the elections are coming, going to be held. But look here, the country had a duty to prepare for these elections immediately after the March election of 2013, 4 years. The court is apologizing for the lethargy and the mediocrity of our national institutions, including IEBC, and says, let us bear with the mediocrity that have not dealt with the timelines.
New commission just came in a month ago, and that the same political parties had said that we should not have the former IEBC proceed with procurement, etc. issues until a new one was
you know very well, Anne, that even as early as February, if this new commission wanted to do its work, it would have done its work. It started playing politics, it would still have done it. Secondly, the secretariat at the IEBC was intact, and it's the one that does the job.
And I need to correct Prof somewhere.
No, I'm
okay, Prof, you have like 30 seconds.
Yes, I'm just finishing. So, in my opinion, the ruling, let it not look like August, the constitution for setting timelines of August, it is the one that made a mistake. The constitution never made a mistake, because we knew 4 years ago that we shall have August. So for the courts to say, because we don't have time to reach August, let us just proceed without looking at the constitutional principles, in fact, it was wrong, and I don't support that.
I'd like to differ with Prof to a great extent. When you talk of Article 10, and we also talk about Article 227, which the petitioners were relying on, when they say that there is need for public participation in this process. And perhaps you are interpreting the ruling differently. My understanding of it is that at no point did the court say that public participation is not necessary. If anything, the court went ahead and said that public participation is important and it is justiciable. It's something that each and every individual or has to take care, has to look into. However, it also relied on the issues of timelines, and I think this is where IBC has been relying all along. That the timelines created, we could say they had 4 years, they had all this time. They were also acting on the timelines. And that ruling said that these timelines are also set out in law, of which now the trial court, it says that the trial court should have made itself aware that it had timelines that it had to follow. And it is for this reason that IB said, given these timelines, we are not able to do what? We are not able to proceed with the open tendering. And so they even sought advice. And they were told, under these circumstances, do what? Go for direct tender. So they did go for direct tender on that basis and following advice. And this is evidence that was presented. Let me finish.
Sandra, where does direct tendering in the Constitution exempt you from observing Article 10?
Article 10, they did. That is when the problem comes in. And so the court also says that it follows on the procurement and public. Let me finish. Go
ahead, Sandra. Go ahead.
Public procurement, Sandra, is inferior to the Constitution. The law is inferior.
That is where the problem comes in, because some of the arguments were this is a constitutional matter, and on the other hand, it's also an administrative matter. And so the court also pronounced itself on that and said, as much as it's a public procurement issue, they still have guidelines they need to follow.
You know, Prof, come on, three things. You know, let's be serious on this issue. You know, we have 3 weeks to an election.
I'm super serious.
Yeah, we have 3 weeks to an election. If you're talking about public participation does not trump the public interest in a context of this nature. So it's an important consideration, but it must always have a context. That's number one. Number two, I think we forget that there had been a contract tendered to print ballots long before January. And through an open process. It is the court itself that cancelled that initial process and said that any process that was done by the previous commission must be stopped. We must start afresh. There has been several orders given by the court that has brought, so it is not just a failure of IBC, it has actually been the failure of other institutions. So it is to say that at the end of the day, while we must have public participation, while we must respect the Constitution does not operate in a vacuum. The Constitution operates in a context, and you must always weigh the constitutional provisions on one side against others and ask what is in the best public interest.
Go back to Article 10 and tell me, we want to be systematic, because we can lose the argument. I have, this is a distinguished lawyer. He's inviting us to say that when Parliament sits somewhere around Uhuru Highway, and then he says, we have passed a law on procurement, this law, and then they say, this law says that when it is directive procurement, we can violate Article 10 of the Constitution.
By the way,
and if I could, even that act in itself, in its introductory phase, it says that the whatever public procurement you'll be doing, we do it in accordance with Article 10 and Article 221, so that the rules being made therein are being made in accordance and in respect of the Constitution.
Professor, and I'd like to give a layman's interpretation of the ruling today, because I'm not a lawyer. But I'll tell you this. Number one, I agree with you that the Constitution is superior, and that is understandable by everyone. But we need to understand that special circumstance calls for special wisdom. And that wisdom lies upon any judge who is ruling on a matter of public interest to rule in a manner that maintains public peace and maintains the prosperity of our nation moving forward. And the reality of the matter, had the courts today ruled and said that we are going to support not printing for Al Ghurair and beginning a retendering process in a competition where neither NASA nor Jubilee trusts the other, in a competition where conspiracy theories of policemen, army people, NSIS, and everyone is involved in a rigging ploy, then it would have created a place where we are walking into an election where there is no possibility of trust even upon the IEBC, because every conspiracy theory then has legs.
Okay, we're running. That's the issue. Gentlemen, I can't believe that time has escaped us a question.
I'm shocked about this.
You'll need to be shocked in silence, Prof, because we have to move on. I beg your pardon. Kamodo, let me come to you now. Are IEBC's main legal challenges out of the way, or do there remain some significant ones that could cause some, disturbance in the process?
The ones that would cause a delay of the elections at least are gone, assuming we won't go to the Supreme Court and it gives a stay. But there are two cases that are pending decision. One is pending decision, one is pending hearing about the question of the complementary mechanism, where the applicants are arguing at two levels. They are arguing on the one that the provisions that allowed a complementary mechanism are unconstitutional. Now, if that was found to be true by the court, then it would mean that we'll have to follow an electronic system. That is not necessarily a bad thing, but it could give us problems during the actual elections.
Right.
In case technology, and I always say technology fails, technology can fail even in this studio.
Right.
So let us recognize the need for the only question is, how will that complementary mechanism be managed? That is what the other case is dealing with, which I think the decision is tomorrow. Depending on what the court decides, that could complicate the logistics on election day, but it will not mean a postponement of the election. Yeah.
All right. Prof.
Yeah, but, that's true. But as you understand, my brother Waiganjo, you see, the postponement of the elections could still be manipulated within Parliament, and it could still work.
So Parliament has gone home.
Yeah,
so
no, wait. Yeah. But the problem was, you cannot extend the date of election without extending the office of the president, the tenure of office of the president. So that's where the problem was, and it would require a referendum. So I want to say that I'm happy that we're going for an election, but if you look at this water and you realize that somebody has put poison in this water, and then you say you are so thirsty you will die, take the water. And it's
which is the poison? The poison would have been a decision. The poison would have been a decision that leaves us uncertain.
Yes, no.
That was the poison.
The other poison is that now many people are going to make laws to say directly.
No. You need to read the ruling by the court. By the way, the court upheld the need for public participation. It always said public participation has a context. We are not slaved to a particular mode of public participation. Let's allow it, but let's recognize there's something called a broader and larger public interest.
I think you're making the good professor sad, and I want to give him a bit of good news. A bit of good news is that one of the cases that is there and is the 7 hours to deliver results. That's good news. It means the election will be up and over quickly. That's one ruling I'm really looking forward to, so that we know how long we get the results and we can all rest.
And we can all go home.
Professor, there's good news. Put a smile on your face.
No,
all right, we'll talk. We're out of time.
INBC is the referee. We wish them well. Actually, it's in our interest to have this election done. A lot of people have lost weight, including analysts like ourselves, because of this. So, but what we really need to do is that the referee must do a good job.
That's true.
From now on, IEBC should stop listening to political factions and play by the rules. And if it does that, it will minimize a lot of problems. Look at this evening we hear that somebody saying, you know, some fellows are being recruited. IEBC should close eyes and say, what did the parliament tell us to do? Yes. What did the people of Kenya tell us to do? This is the framework. We are playing to the rules, and then the election will be held well. We might not be a perfect situation, but it will come out well.
Sandra, your final thoughts?
I'd say I'll agree with Prof and say that we are looking for perfection, which is impossible. What we need to, and we've said this before, what we need to work towards are certain minimums that we as a country can agree on and say we did have a free and fair election. That being said, I think at this point I want to say that I'm really proud of the IEBC. They've tried, given from where they were coming from, and it is my hope that moving forward we are going to have a free, fair and peaceful election period.
All right. Mark?
My take on this particular issue is very simple. Number one, I think politicians should stop with the conspiracy theories. The problem with conspiracy theories, if you look hard enough in the dark, you'll always see a ghost. That's the problem. You know, we are acting like we are children in our rooms, and every sound, everything, we are bringing it to the media, and we are heightening tensions in this country. I think the political propagandism and should really die down so that we create public trust in the IEBC, because we will need that trust, because we will need this country after this election. That's the most critical thing for me. We need to get to the point where as politicians we are banking trust on the IEBC so that Kenyans can trust the IEBC. Last thing is the IEBC needs to manage the expectations of Kenyans. The Kenyans need to know how long is the queue, what should I expect, what should I carry, should I carry water. They need to be told. There is no such thing as too little information in a matter of this importance. The IEBC should come out and manage the expectations of Kenyans.
Come on.
Two things. One is to say, Kenyans are as a little more sophisticated than we think. I think Kenyans now know when people are just talking gas. You know, there are so many things that are thrown about and there's no evidence given that Kenyans don't take a lot of politicians very seriously anymore. That's number one. Number two is that if I was to speak to IEBC, I would repeat something we have said here many times before. This is the time to actually ignore the politicians and look for other constituencies. Ensure that there are people understanding your challenges and understanding what you're doing and understanding where you're at, so that we are moving together, not to please the politicians, but to address the most critical constituency, which is called the other Kenyans. And if we were to do that, even when things go wrong, because things will go wrong on August 8th, we will know we have an institution we trust. And that is more important than getting it right technically, getting a trustworthy commission. And the next 2 or 3 weeks, the commission must invest all its energies in being credible, trustworthy, by increasing its constituencies.
I thank you all for your views. Edward Kisengani, our resident analyst, Sandra Chola, governance analyst, Kamodo Waiganjo, lawyer, and Mark Bichachi, communications strategist. Thanks for watching Citizen Live at 9 and Opinion Court. I am Anki Guta. God bless you and good night.